To the right corner YouTube channel, social media is in an uproar over the news that Minister Motsoaledi bids to appeal the Zimbabwean exemption permit ruling has failed. Users are sharing their thoughts and opinions on the matter, and the conversation is really heating up. Will this be the end of this program? Let's try to find out more on what other ex-users are saying in relation to this case. Getting into the story in detail, Motsoaledi fell in bid to leave for leave to appeal ZEP ruling, News 24 reports, and this is from Wopwe Chingono as he posted that the Gauteng High Court in Pretoria dismissed Home Affairs Minister Aaron Motsoaledi's application for leave to appeal its Zimbabwe exemption permit ruling. The court ruled in June that Motsoaledi's failure to consult with ZEP holders, interested NGOs and the public was unlawful, unconstitutional and invalid. The court dismissed his application with cause. The Gauteng High Court in Pretoria has dismissed Home Affairs Minister Aaron Motsoaledi's application for leave to appeal against a ruling on his decision to terminate Zimbabwe exemption permits ZEPs. The court ruled that Motsoaledi's failure to consult with ZEP holders, interested NGOs and the public was unlawful, unconstitutional and invalid. At that time, the court extended the permits for 12 months from 28 June, pending the conclusion of a fair process that includes an adequate public participation process. The court found had not been done before the 7 June Gazette for the ZEP termination. The court ordered that ZEP holders must be allowed to leave or enter South Africa and may not be dealt with in terms of Sections 29, 30 and 32 of the Immigration Act on the basis that they are ZEP holders. News 24 previously reported that the minister applied for leave to appeal against the judgments, which he said set dangerous precedents. The department said those were the findings of the court on the applicability of certain sections of the Promotion of Administrative Justice Act (PAJA), which the Department of Home Affairs said was highly questionable, particularly the requirement for public participation when a decision of this nature is taken affecting a specified category of persons only. In this instance, the affected Zimbabwean nationals, Motsoaledi also appealed because he believed that the matter dealt with the separation of powers, to which the court ruled his grounds for application for leave to appeal were flawed. In its judgment on Monday, the High Court said Motsoaledi's application was destined for failure because he did not depose an answering affidavit in the review proceedings. Quoted, only the minister as the decision-maker could give evidence as to what passed through his mind and how his mind was exercised, the judgment read. The rest of the minister's grounds for leave to appeal are not necessary to traverse. It is enough to conclude by pointing out that the court was at pains to explain that its order under Section 18(1)(e) of PAJA was temporary relief, which is distinct from a substitution order under Section 81(c)(2)(aa) of PAJA and is just and equitable remedy in terms of Section 172(1)(b) of the Constitution. The court dismissed the minister's application with cause and reported the links to News 24, which means that's where Wopwe Chingono had got the news, and Rutendo Matinyarare also had to break this down as he wrote on his X account that Aaron Motsoaledi's appeal fails as court humanizes Zimbabweans. Aaron Motsoaledi attempted to appeal the July 2023 court decision that said that the cancellation of the ZEP permit was unlawful and unconstitutional because it lacked consultation with the affected people, NGO, and South African citizens. Motsoaledi argued that the people affected by his decision were Zimbabweans, suggesting he didn't need to consult with them as if they were non-human and didn't enjoy his rights enshrined in the constitution, which mandates that all laws made in South Africa must undergo public consultations with those living in the public who will be affected by the law. He also conveniently forgot that ZEP holders, being human, have economic, personal and social ties with their communities, and South Africans who are likely to be affected by a decision to remove those Zimbabweans from South African society. Thus, those South Africans also deserved consultation. The court also raised concerns about the minister not personally providing an affidavit that explained his thought process and his state of mind when he decided to cancel the permits without consultation, and his decision to appeal the court's temporary relief. Consequently, the court dismissed the case with cause, saying that his appeal had no prospect of success. This case makes it clear that ZEP holders are human beings with the same rights as any other South African, and these people cannot be denied their rights just because they are Zimbabweans. This effectively gives Zimbabweans indivisible and inseparable human rights to those of South Africans in the public. He goes on to mention that this decision means Zimbabweans on the ZEP should be allowed to travel in and out of South Africa without prejudice between now and June 2024, pending the Department of Home Affairs undertaking consultation and notification of their intention to cancel ZEP. The decision also prohibits the mass deportation of Zimbabweans who are not on the ZEP permit. It said that Zimbabweans had to litigate against a friendly government that is under pressure from its citizens to persecute African immigrants because of high levels of poverty. This is a lesson to the South African government that it must redress the uneven and unjust distribution of resources to its people who were dispossessed by apartheid instead of scapegoating foreigners. This was Rutendo Martinez's analysis of the story that South African Home Affairs Minister Motsoaledi loses ZEP court case.